Good afternoon. Welcome to this week's edition of the Crow and Dunleavy virtual webinar series. My name is Michael Bowling, and I'm excited to be with you. Today we're going to talk about this last year's Supreme Court decisions, so prepare for takeoff. Before we get into that, I want to address a few housekeeping items so that we all have a good experience today here on the webinar. Sorry first that we got started just a little bit late. Hopefully all of you have, not that you've experienced technical difficulties, but during the pandemic, I think we all have experienced some technical difficulties, and so it took us a couple extra minutes to get going. One of the key things that I like about presentations, one of the things I think is most fun, is actually the dialogue between myself and the people who are in attendance. And that's a little harder when we do it here virtually via Zoom, but I do want you to feel comfortable submitting your questions so that we can try to get that dialogue going. If you'll submit your questions using the Q&A function, then Stephanie is sitting here, not next to me, but distanced from me in the room, and she'll get my attention during the presentation, and we'll review those questions and get as many answers as we can. For many of these webinars, we've gotten more questions than we could possibly answer during the webinar. And so if I don't get to one of your questions today during our time together, then we will follow up in the coming week with any questions that you might have via email or phone. So you'll definitely get your question answered one way or the other. I also wanted to let you know an exciting thing about today. We will be giving away a Southwest Airlines gift card to one of our lucky attendees. And so I'll be announcing that at the end of today's webinar. Also, you'll be getting a copy of the slides from today, as well as information about HRCI and SHRM credits via email tomorrow. So hopefully that takes care of all the housekeeping. If I miss something, you can just use the Q&A function, and we'll make sure to get that question answered. I'm trying to advance the slides, but we have just a bit of, I'm having a technical challenge. There we go. So we're going to start off with probably what everybody thinks is the biggest decision from the Supreme Court, especially when it comes to employment law from the last term, and that's the Supreme Court's decision in Bostock versus Clayton County, Georgia. The decision came down from the Supreme Court in June of this year and addressed whether or not Title VII protected individuals from adverse actions by their employers on account of their status of being gay or transgender. And I'm sure, as everyone on here recognizes, the Supreme Court did hold in a 6-3 vote that an employer who fires an employee merely for being gay or transgender takes action because of sex, and action because of sex, it violates Title VII. The court's reasoning here was that where an employer terminates an employee because the employee is gay or transgender, they said sex plays an necessary and undisguisable role in the decision. In reading the opinion, in order to understand better what the justices were thinking, I think they gave one example that brings very clearly why they reached this decision using the language of Title VII. And this next paragraph is actually from the opinion. Justice Gorsuch stated, consider an employer with 2 employees, both of whom are attracted to men. The 2 individuals are, to the employer's mind, materially identical in all respects. And it's important that he said that there. Typically, when we're litigating about employment issues, we try to point out why employees are different from each other and why they got treated differently because of their differences. And Justice Gorsuch wanted to point out that in his example, there's no difference from a performance perspective, job duties perspective, supervisor perspective, all the reasons we might distinguish people, that there's no distinction between these 2 employees, except that one is a man and one is a woman. If the employer fires the male employee for no reason other than the fact he is attracted to men, the employer discriminates against him for traits or actions it tolerates in his female colleague. As a result, adverse actions that turn upon the sex of the employee are exactly what Title VII forbids. I think many people were actually surprised, not only by the ruling, but also by the number of justices who voted for this result, and the fact that it was actually authored by one of the newer justices, Justice Gorsuch. However, I'll kind of do some foreshadowing on the overall presentation today. You'll notice over and over again today, as we talk about what the Supreme Court did this last session, that the language of the statute plays a predominant role for this group of justices. That's particularly true overall for the more conservative justices, but even plays a key role for what we call the more liberal justices as well. And in this case, the justices found that whether Congress intended it or not, and they specifically said we're not addressing what Congress intended, but instead the words that Congress used. And in this case, because they used because of sex, they found that people are not would only take these decisions because of the sex of the employee. Now, before we go on, we're going to do some poll questions today during the presentation, and we're at our first poll question, and these are designed to help us interact more. So you're going to see the question pop up, and the question today is, has your company made any changes to policies or procedures in the wake of Bostock? And you'll have 3 answers, yes, no, or not quite yet. We're in the review process, meaning, you know, we noticed it, we've seen that it's out there, but we haven't done anything different. You'll have 45 total seconds, so you have about 20 seconds more to answer the question, and we'll see where you guys land. Looks like we're headed heavily toward no changes to policies or procedures, and there could be a number of reasons for that, which we can talk about in just a moment. So I think we're about at poll closing. There we are. So yeah, we had 74% of you said that you have not made any changes to policies or procedures in the wake of Bostock. 10% said yes, you have, and 16% are in the review process in determining whether you need to do that. So that's very interesting for us to, and we can talk through some of the things you might want to think about and some of the reasons that you might not have made those changes. Let me close that down. There we go. So what are some thoughts? And as we go through this presentation, I do want to focus heavily, not just on what the court decided, but how you're actually supposed to deal with it, because I think that's the most valuable thing about any yearly Supreme Court review is what impact is it going to have on your workplace and the things that you do. So from a next step perspective, I want to talk through some policies that you'll want to think about looking at. The first and kind of, I think, most obvious is the equal employment opportunity or harassment policy that you have. And I say that, that you have, while technically the law does not require you to have an EEO or harassment policy, I think that no matter the size of your company, this is a policy that we would always recommend that you have. Technically, I think I've used that word over and over again, if a policy prohibits discrimination on the basis of sex, it is still compliant with Bostock because Bostock turned 100% on the definition of because of sex. The key thing about policies, though, is how you communicate with employees. And if your employees, particularly your supervisors and the people who are supposed to be being protected, wouldn't understand that not changing your policy means that you've now changed your policy to ensure you're not discriminating on the basis of sexual orientation or gender identity or transgender status, then I think the recommendation should be that you, in fact, go ahead and make a change to the policy. So even though sex does now and is interpreted to include both sexual orientation, gender identity, and transgender status, from a legal perspective, most people reading a policy are not going to read it that way. So in the wake of Bostock, I'd recommend that you go ahead and add sexual orientation, gender identity, and transgender status to the list of protected classes that are covered by your policy. That way there's clear communication to your workforce that you understand the change made by the Supreme Court. If that is a change for you, some of you may have already made that change. The EEOC has been of this interpretation for a number of years now, and if you've updated your these policies or your handbook in the last few years and worked with an attorney, there's a high likelihood that you've already included this. But if you haven't, then this is a good time to go ahead and make that change. One thing to note, you may be saying, I don't agree with this change. The challenge is, whether you agree or not, it is the law of the land. It's particularly if you have at least 15 employees. So if you have at least 15 employees or average at least 15 employees, then Title VII applies. And so without regard to the personal feelings of the owners of the company, the board of directors, or the supervisors, Bostock is the law of the land and the interpretation of Title VII that we have. I say 15 and above because Title VII does not apply under 15, but the Oklahoma Anti-Discrimination Act does. As a general rule, the courts interpret the Oklahoma Anti-Discrimination Act in the exact same manner as Title VII, the Americans with Disabilities Act, the Genetic Information Non-Discrimination Act, and other, the Age Discrimination Employment Act. They all get, the OADA gets interpreted the same way. But I have yet to see anyone actually litigate this specific question under the Oklahoma Anti-Discrimination Act. So it is possible that the courts would reach a different conclusion with respect to the Oklahoma Anti-Discrimination Act and may conclude that it applies differently than Title VII. I wouldn't bet a single dollar on that, but as an attorney and as somebody who knows somebody's going to make that argument, I didn't want to communicate that as well. You'll also want to think about your dress code policy. If possible, it's good to avoid any and all sex-specific dress code guidelines. So if you currently have sex-specific dress code guidelines, you're going to want to look at them and say, do we even need these? Is there a legitimate business reason that undergirds us giving different direction to men versus to women, or to people who identify as men versus people who identify as women? If sex-specific guidelines are necessary and there's a legitimate business reason for them in your workplace, then you're going to want to ensure that you apply your policy based on the employee's gender identity, not the employee's biological sex. So if a person identifies as male, then whatever guidelines you have for male employees would apply to that person, no matter their biological sex, and the same if the person identifies as female. Now, one of the things that has been most challenging in this litigation over the last few years, and there's been a lot of headlines about various court decisions, is restroom and locker room usage practices. I actually gave advice about this within the last week for an employer that was wondering what it should do in the circumstance of an individual whose gender identity was changing and which restroom were they supposed to use. The Supreme Court did not expressly resolve questions about restroom or locker room usage. In fact, they specifically said they were not reaching that. So I think we can expect litigation over the next few years related to this. However, I don't think we should read too much in the court saying that. The Supreme Court is very careful to only answer the specific questions that are asked of it. And the three consolidated cases that are addressed in Bostock, restroom usage did not come up. Neither did locker room usage, so the court does not answer questions that are not posed to it. So I would not read a lot into the court saying that. At this point, the EEOC's interpretation of Title VII, which is consistent overall with the Supreme Court's resolution in Bostock, provides that people should use the facility that matches their gender identity. So your best practice is to provide a single-use unisex restroom where possible, or to allow employees to use the restroom or locker room that matches their own gender identities rather than their biological sex. This is a best practice because it's most consistent with Bostock and it's least likely to make you a test case defendant, which I don't think anyone wants to use corporate resources in order to be a test case. The challenges that can come up with this are both in helping the person who is in a transition mode or who has changed their gender identity, but also other employees who may state that they're feeling uncomfortable. We could probably do a full hour on how to manage these types of issues. The thing is, you just want to, politely, kindly work everyone through this. To the extent that people feel uncomfortable, it's important to talk about that you want to protect people based on their gender identity and you're not going to discriminate. And that applies not only to the company as an official entity and the supervisors, but it applies to coworkers as well. And that while people may or may not agree with this or may see this in very different lights based upon their own feelings and opinions and beliefs, that you want a workplace that doesn't discriminate and that people can feel comfortable being in, and that applies to everyone. Now, to the extent, and I say this only because this can come up, but I actually don't put a lot of credence in it, that some people may complain they feel uncomfortable, that there may be staring or odd behavior from the person who is expressing a different gender identity. Most of that is actually about the discomfort of the other people. But to the extent someone is behaving badly, you would handle that the way you'd handle any poor behavior overall. So if somebody is doing something in the locker room or in the restrooms that is inappropriate, you're just going to handle that as a performance issue in keeping with your corporate values, your corporate guidelines, and your desire to protect people from inappropriate behavior. And so that's not going to be about the person's gender identity. That's going to be about their behavior in the restroom or locker room. So it's important to distinguish between those two things and know when you're acting because someone's doing something they shouldn't versus people's stereotypical feelings about the person's gender identity. I've discovered a typo already. So this slide is actually about Comcast Corp versus the National Association of African American Media, and it should say the same thing at the top. This is not another Bostock slide, so that's on me. We'll get that fixed before we send this out to you tomorrow. This case came down March the 23rd, 2020, and it deals with 42 USC section 1981. If you've ever had a race discrimination claim brought against your company, you've probably had both a Title VII claim, because Title VII protects against discrimination on the basis of race, and a Section 1981 claim, because due to a Supreme Court ruling in the 1970s, there's a recognition that this statute, which technically, once I said it again, maybe we should have given away a prize for the number of, if I hit the right number of times of saying technically, that this statute, which talks about protecting people against race discrimination, the formation of contracts, extends to the employment contract that exists between every employee and their employer. So that's what Section 1981 is all about. And in this case, the court was deciding what was the standard for proving an injury that would violate Section 1981. And they ruled that the standard was that you had to prove that but for the person's race, they would not have experienced the injury, the lack of contract, being terminated, whatever it is. There was an additional question that was attempted to be brought forward, and that was, does Section 1981 protect you throughout the contract making process? And the court specifically did not answer that. This was a unanimous ruling, so there's not any question about the court in the near term coming back to this. Everyone on the court agreed. The reasoning of the court was that in tort, which is the law, there's law of contract and law of tort, where people claim injury unrelated to contract. The presumption is that a tort plaintiff must show that the defendant's action or decision was the but-for cause of the injury. And so rather than simply a motivating factor, the court said to prevail, a plaintiff must initially plead, that means include in their petition or complaint, and ultimately prove that but for the race, it would not have suffered the loss of a legally protected right. And really the court's given the indication here that unless Congress says differently, the background to everything Congress does when it comes to setting up employment discrimination claims and really tort claims overall is that the court will assume but for causation unless Congress uses other words specifically. And the court could find no indication in the statute or more recent congressional action to show that it should depart from this traditional view. So what are next steps? Really, the practical implications for employers of Comcast are limited. Long-term, the lower courts are going to wrestle with this decision of whether Section 1981 protects only in the ultimate contract formation phase, or whether other steps in the contract making process are likely to be more meaningful. If I was looking in the crystal ball, I would say that in fact, they're going to find that the contract making process is fully protected under Section 1981, but that's just me. And if you want to write that down and check against the litigation that occurs over the next decade, you can get back in touch with me about whether I was right or not. But I think that's where we're going to head. Either way, the way to avoid liability here, and really what should be in keeping with your corporate values, is that race should not be a factor at all anywhere in the decision-making process. It doesn't matter whether you have, kind of initial steps that you think might be protected against Section 1981 view, the right thing to do is just ensure that race is playing no role whatsoever in any of the decisions you're making about how to treat your employees. Then we have the case of Babb versus Wilkie. This came down back in April of this year. And this is probably not going to have much impact for hardly anyone on the phone, except those of you who have worked in the federal sector or may still be in the federal sector today, because this case was solely about the federal sector section of the Age Discrimination Employment Act, which is different from the private employer section of the ADEA. The federal sector section has a different wording than the private sector section, and as a result, once again, it came down to language. The court found that personnel actions must be free from discrimination based on age. So the but-for standard does not apply to the overall question of age discrimination, but the court found that but-for causation does matter when it comes to remedies. This was an 8-1 decision, so an almost unanimous court. The reasoning for getting to this spot by the Babb court was once again the specific language of the statute. The court did not go back to, well, what did Congress intend, or what did people state in the speeches they made on the floor or the committee reports. They stopped at the language that was being used actually in the statute, and the statute specifically in the federal sector section provides that personnel actions must be made free from any discrimination based on age. And so the court took Congress at its word, holding that age cannot be any factor, not just a motivating factor, not just a but-for factor, but any factor in federal personnel decisions. So that really opens wide the scope of what federal employees can complain about when it comes to actions within the federal government. However, and I've got but, and it should be, you should see it bolded there. I should have bolded, underlined, italicized, and made it all caps, because the but is huge in this case. Federal sector plaintiffs still have to show but-for causation in order to get most of the critical damages available in employment discrimination lawsuits. So they have to show but-for causation to get reinstatement or back pay or compensatory damages or any other forms of tangible relief. The court said that it is bedrock law that requested relief must redress the alleged injury. So a good example might be, let's say that you have a university professor, it's not a university professor, let's say you have an employee at a federal agency who says, well, gosh, I didn't get promoted, and as a result, and it was because age played a factor. And let's say the evidence actually showed that yes, age played a factor, but that even though age played a factor, it wasn't the but-for cause, right? So even though the people considering the individual for promotion thought, maybe he's a little old for this job, they still would have picked a different person because of the person's qualifications. So they actually took into consideration the plaintiff's age, which is not permissible and violates the ADEA federal sector section, but they still would have picked the other person based on the other person's qualifications anyway. So their decision was not free from discrimination, and so it violated the ADEA, but that age consideration was not a but-for cause of the decision that they actually reached. And so in this case, it wouldn't be fair to grant that person the promotion or to give them additional money because they didn't get the promotion. They weren't getting the promotion anyway. And that's why the court reached this conclusion on but-for causation. So they said that if you don't show but-for causation, that federal sector plaintiff's going to be limited to injunctive or other forward-looking relief, which would basically mean a court order telling the agency, in this case, in my example, to not use age anymore in their decision-making at all. And that's what you're going to be limited to. Now, that's a big but for the federal sector plaintiff, but it's actually good news for employment attorneys, plaintiff employment attorneys, I should say, because any judgment that they get entitles them to attorney's fees. So in these cases faced by the federal government could see itself paying out more in attorney's fees under the ADEA, because even if the federal sector plaintiff can't show that but for age, the person would have not been injured, and just can show that it played some role that wasn't free from discrimination, that's still going to be a judgment. So this case was a good day for plaintiffs' attorneys if they're suing the federal government. We've gotten to our second poll question, and so the poll's going to come up there. We're about to hit some cases where this is relevant, so I wanted to get this question up there. The question for you is your organization a faith-based organization or religious institution? If it is, then you answer yes. If it's not, then no. Or, the next few cases may still be relevant for you if you kind of help with HR issues at your church or synagogue or mosque. I know a lot of people kind of on the side, because of their expertise, can help provide that kind of guidance to their own faith-based institutions. And so that's why we have that third option there. And so we've got 15 more seconds to consider that question. Coming up on 5 seconds. And it's not a surprise here. As we close out this poll, the 89% said no, you're not a faith-based organization or religious institution. So the next couple of cases that we'll talk about will really be a little bit more academic for you all. For those of you who are in a faith-based organization or religious institution, these will be relevant for you. Or for the three of you who do give advice to your church or synagogue or mosque or other faith-based institution, they could help with you providing good advice to those institutions. So I'm going to click out of this and move us to our first case that really focuses on religious freedom. And this is the case of Our Lady of Guadalupe School versus Morrissey Baru. And this came down in July of this year. And it focused completely on what's called the ministerial exception under the First Amendment religion clauses. And it said that ministerial exception prevents these Catholic school teachers from bringing their employment discrimination lawsuits. And it was a 7-2 decision, so the court overall had a high level of agreement about the application of the ministerial exception. So what is the ministerial exception? It's this idea in the First Amendment doctrine that seeks to avoid government interference in the relationship between religious institutions and their key employees. This was an exception that was codified from a Supreme Court precedent perspective a few years ago. And the courts really, the lower courts since that time have been kind of figuring out exactly what is the scope of this ministerial exception. And the Supreme Court was called upon this last term in order by a decision of the Ninth Circuit to really clarify what it had meant when it made it part of Supreme Court jurisprudence. The ministerial exception is available where an employee's duties are specifically tied to an organization's religious functions. That's actually pretty easy to say if you're talking about a pastor or a minister or an imam or a rabbi, someone whose entire job is really focused on in kind of imparting religious doctrine of an institution to the congregation. In this case, it was about teachers, and actually the first case that came to the Supreme Court where they did the ministerial exception was about teachers as well. And in each of these cases, the court found that the teachers in question, part of their job was actually religious education of the students who went to these church schools, and that was definitively wrapped up in the religious function of these organizations, that part of going to church school is learning the church's perspective, a religious perspective on the world, and that these teachers had, as part of their job functions, that they not only taught religion, but they participated in worship with the students. And so the court found that it was actually a pretty easy answer to say that the ministerial exception applied to these teachers. The reason that the case even made it to the Supreme Court is the Ninth Circuit took a look at that prior decision by the Supreme Court and looked at the factors the court talked about in that case and created kind of a rigid test and said unless an employee meets this rigid test of duties, then the ministerial exception will not apply. And the court said that's not actually what we intended. We did not intend a rigid test, but in fact, something that is really looking at the circumstances of the particular employee and whether or not those circumstances lend themselves to fitting within the ministerial exception. So next steps, and for those of you who work for religious institutions, the court emphasized in both this case as well as in the predecessor case, which is Hosanna Tabor Evangelical Lutheran Church and School, the employer's perspective on the duties of plaintiffs. courts always take into consideration the employer's perspective in employment discrimination cases. However, they really emphasized it in a different way and elevated that employer perspective on these duties in both of these cases. And I think that's important if you're working in kind of the HR aspect of running a religious institution, that these religious institutions should focus on documenting the duties of employees. Particularly those where they believe there is, in fact, a ministerial function, a function for the employee to minister to others about the specific religious beliefs of the institution, and that these institutions should take pains to actually emphasize those aspects of the job that are specifically tied to the organization's religious function. So I know that a lot of churches don't necessarily operate with job descriptions, and religious institutions may they have other things they're focused on, but I think these cases bring to the fore the importance of kind of really making more formal those things if the organization wants to avoid having employment discrimination lawsuits. I think the case that what can get lost here is that both of these institutions, the Catholic schools in question, as well as this Evangelical Lutheran Church, did not say that they were free to discriminate or that they intended to at all. In fact, they emphasized that their religious beliefs indicated that those conflicts should be dealt with within the church. And that was really the perspective that they took. So the goal of this is not to simply avoid lawsuits, but that's an important part. Lawsuits are expensive, and it's probably better for religious institutions to be able to use their resources in other ways, even as they attempt to remedy these issues within their institutions. We've got another case related to religious freedom in employment law. It's Little Sisters of the Poor Saints Peter and Paul Home versus Pennsylvania. And this one also came out in July of this year. And it held that the federal executive departments, and we'll talk about which departments in just a second, they had the statutory authority under the Affordable Care Act to exempt certain employers with religious or moral objections from providing contraceptive coverage to employees. Once again, not a 7-2 decision, so it wasn't a close call in terms of where the court was going to land. The reasoning of the court was actually based solely, once again, on the language of the Affordable Care Act. And I think almost every single case today that I've talked about and will talk about, the court just honed right in on the statutory language. And here they looked at the broad delegation of authority to the Departments of Health and Human Services, Labor, and Treasury to determine the scope of the ACA's coverage of preventative care and screenings. Before the current administration, the Obama administration had interpreted preventive care and screenings to include contraception as part of preventative care and screenings. And there was an exception that was added to this, and there was some litigation about this, and we'll talk about that in a second. But this case actually grows out of that prior litigation about whether or not there could be an exception to the provision of contraceptives under the preventative care and screenings. And so while the litigation indicated that the departments actually probably needed to go that direction, the Departments of Health and Human Services, Labor, and Treasury here found that they actually had the power to go ahead and create an exceptions process to the contraception mandate solely by virtue of the delegation of authority to them. And the court agreed. The court said, since they get to broadly define the guidelines, that by virtue of that delegation means they also get to define the exceptions to those guidelines. The next steps. So once again, this is a case that has little practical impact for employers unless you're a religious institution or a closely held corporation. It also could be faith-based not-for-profits. And if you're one of those and have an objection to contraception, then this is going to apply to you. So right now, there is a process within the federal government where you go through your insurer, where these institutions can actually state we have an objection to providing contraceptive coverage under our ACA covered health and welfare benefits, and so we're not going to provide it. And there's a method for having that. I don't think approved is quite the right word, because these plaintiffs would assert that they do not need the approval of the federal government in order to make those objections. But there's a process for basically registering that objection for qualifying institutions. And that's not just any company. It has to be one of the qualifying types of organizations. And so while Little Sisters confirms this departmental process, it's important to remember that it is simply a departmental process. And so since that process is based in regulation, it could be changed by the next administration, because the court did not actually reach the follow-on question, which was, is the process required by the Religious Freedom Restoration Act? And that is unclear. While there was a holding in the Hobby Lobby case a couple of years ago that the Religious Freedom Restoration Act applies to closely held corporations and could allow them to assert these types of objections, for example, to contraception, the court did not hold that a specific process for creating those exemptions existed. And so that question has not been answered. So it's possible that the next administration may want to change that process and that we could see more litigation about this in the future. Hey, now we're here to poll question number 3. We've got about 20 more minutes, and so we're going to deal with what I think everybody thought was going to be the most exciting part of the presentation, and that's ERISA issues. So your question here is, does your company sponsor any ERISA-covered health and welfare or retirement plans? You've got 3 options, yes, no, and what's ERISA? I got 45 seconds, so nobody has said what's ERISA, which is, oh, there, we've got 3 what's ERISAs. Great, so I'll start with that while we finish out the poll. ERISA is the Employee Retirement Income Security Act. It was passed, goodness, almost 50 years ago at this point. And it actually provides for federal regulation and kind of a big regulatory schema for dealing with employer-sponsored health and welfare or retirement plans. Now, from the retirement plan perspective, if it's employer-sponsored, it's going to be ERISA covered. From a health and welfare perspective, ERISA applies to self-funded plans, not fully insured plans. So if you simply pay premiums to an insurance company and they provide the insurance for your employees, then that is not an ERISA covered plan. If you are self-funding your health or welfare benefit, then that's going to be ERISA covered. And that's an important distinction, because many employers actually will have some self-funded portions of their plan and some fully insured portions of the plan. And so that means you can have health and welfare benefits that fall into both groups. And so you'll just want to be aware of that. But it does look like, 76% of you sitting out there today do sponsor ERISA covered health and welfare retirement plans. So what we're going to talk about in the next few cases is actually going to be applicable to just about the vast majority of people on the call. So our first case is Thole versus U.S. Bank N.A. This one came down in June of this last year. And this one is actually specifically about whether the participants in a defined benefit retirement plan who were guaranteed fixed payments regardless of plan value were able to bring a claim under ERISA. And this is a very specific type of ERISA covered plan. So there are 2 different kinds of retirement plans. There are defined benefit plans and defined contribution plans. Most of you are probably doing defined contribution plans. That has been the wave of the future for quite a while now. But a defined contribution plan is basically a 401k type device where people put in a defined amount, but what they're going to get in the end is dependent upon both their investment choices and the performance of the market. A defined benefit plan is one where no matter the performance of the assets, you've guaranteed actually what the person's payment is going to be. And so the employer bears 100% the risk of whether or not its own investments and its funding of the plan is going to keep up, or whether it keeps having to put money into the plan in order to make up for poor performance. In this case, the court held that to bring a lawsuit in federal court, and this is true overall, the plaintiff has to be able to assert that they had a concrete stake in the lawsuit. And the plaintiffs here, Mr. Thole and Mr. Smith, had actually had no disruption in their retirement payments. They simply contended that the investment committee that was in charge of the retirement plan was making bad decisions, and that impacted the value of the fund. But the court said, if you stand back, They said if Thole and Smith were to lose the lawsuit, they would receive the same exact monthly benefit that they were already slated to receive, not a penny less. And if they won the lawsuit, they would still receive the exact same monthly benefits that they are already slated to receive, not a penny more, because it's a defined benefit plan. So no matter the performance of the investment committee, the decisions they made, the investments that they made, Mr. Thole and Smith were going to get the exact same benefit. So because they could not show that they'd actually been harmed, they didn't have the ability to bring a lawsuit in federal court. The court did leave open a little bit of room for better pleading going forward by these plaintiffs. They said that if the plaintiffs asserted that the investment decisions substantially increased the risk that the plan and the employer would fail and be unable to pay the participants future benefits, they might be able to state a case. They didn't say yes to that, but they left open the door that they would consider that question in the future. So while this case should result in a kind of bringing down the number of claims that are being brought over investment committee decisions for defined benefit plans, it didn't shut that door completely, because good plaintiffs' attorneys are just going to go ahead and assert that the actions of the investment committee substantially increase the risk that the plan would fail. And the risk of plan failure is that people don't get their benefits. So that is a real risk. The Pension Benefit Guaranty Corporation actually underwrites defined benefit plans, and companies that have defined benefit plans actually pay a premium in to the Pension Benefit Guaranty Corporation. But we've also seen that some massive pension plans have failed in the past couple of decades, and that the PBGC cannot fully underwrite those liabilities. And so people have lost significant portions of their retirements as a result of companies going bankrupt and not fully funding or being able to fund their defined benefit plans. There's really little practically that you can do with this, so we don't have a practical kind of next step slide here. It's just something to be aware of as you react to litigation. It's also something to think about as you consider the health of, if to the extent you have a defined defined benefit plan, and you're thinking about the health of the plan, being aware that if you're in a stage where it's questionable if you're going to be able to maintain funding, or you're making investment decisions that actually significantly implicate the health of the plan, you're opening yourself up to this type of lawsuit in the future based on that substantially increased risk. Now, here's our poll question 4. I should have had these in the opposite order, but we're going to go ahead and ask it. Does your company sponsor a defined benefit retirement plan? I'm going to get a drink while we wait for the answers to come in. We're actually saying this is a higher number than I had expected on defined benefit retirement plans. So that's just good to keep in mind as you think about the Thole case, that for the majority of you, that it actually matters. The Thole case, and really considering the question of how you're managing plan assets. I once served on a committee that kind of guided retirement plan decisions, and that fiduciary duty can weigh heavily. And it's important that the people who serve on those committees and who are making those decisions actually understand kind of the role that they're playing and the impact that they're having, both so that you're protecting people as they become retirees under your plan, and to avoid liability for the company going forward. The other decision we wanted to talk about today that's ERISA impacting is Intel Corp Investment Policy Committee versus Sulyma. This one came down back in February, and it held that the ERISA requirement of actual knowledge to trigger the 3-year statute of limitations means actual knowledge, not constructive knowledge, and the court made this decision 9-0. So there was no question for the court that this is exactly what ERISA meant. And here was the court's reasoning. There are actually 2 different statute of limitations within ERISA in this particular section, and really 3 different ways of getting there, but there's a 6-year statute of limitations and a 3-year statute of limitations. And here the defendants were saying, hey, the plaintiff had actual knowledge of our alleged fiduciary breach, and so should be limited to 3-year statute of limitations. And in this case, if the plaintiff had been limited to a 3-year statute of limitations, his case would have failed because he brought his case more than 3 years after the defendants were asserting that he had gained actual knowledge. The challenge here was the defendants were asserting that the plaintiff, Mr. Sulyma, gained the actual knowledge through a disclosure that they delivered to him. If you have a retirement plan or even a health and welfare plan, or even if you're a participant, you've probably gotten emails or something in the mail that was a disclosure to you about something that the plan was doing. If you're like most people, and I'll confess myself, you probably just recycle or trash most of those disclosures. Most employees, most participants never read the disclosures that are coming from their plans, except maybe around open enrollment time. And that's about the only time people are really going to interact with this. And in this case, Mr. Sulyma had logged into the website and had previously looked at some disclosures, but he testified in his deposition that he couldn't remember seeing the disclosure, and he couldn't remember having gotten information about the particular investment decisions that he was now questioning as breaches of fiduciary duty. And the court held that unless the defendants could show that, in fact, he had actual knowledge, then it didn't count. Constructive knowledge did not work. And constructive knowledge means you were presented with information that should have created knowledge, whether it created that knowledge or not. And they said constructive knowledge was just not enough. So delivering disclosures to participants is not enough to show that they actually had knowledge to get you to this 3-year statute of limitations. This is a pretty important case when it comes to managing ERISA covered plans, because employers who sponsor these plans, their focus has really been upon just ensuring people get these disclosures, right? Not on ensuring that they had actually read the disclosures, because anybody who's worked in HR knows you can deliver the information, but you cannot guarantee people are going to read it. I'm sure anybody who's been through an open enrollment has found frustration with the number of times you have to explain the same thing that you've already communicated multiple times before. But here the court said it doesn't matter how many times you tried to communicate it, the person actually had to consume the knowledge and have actual knowledge of it. So for those of you with ERISA covered plans, whether it's retirement or not, the Supreme Court case here, while it was about a retirement plan, is about ERISA overall and about fiduciary duties under ERISA overall. So this is going to apply on the health and welfare benefits side as well as the retirement side. You'll want to think about your current method of delivering plan-related disclosures and plan documents. If you want to think about that, whether you're managing that internally or if you manage that through a service provider. And especially in retirement, you're probably managing that through a service provider, but even many of you may be using service providers for health and welfare as well. But is there a way to actually deliver this information in a way where the person has to read the information and affirm their actual knowledge of its contents? That may be something that's doable within your platform. It may not be something doable within your platform. You've probably all experienced the online disclosures that you'll get, probably from everybody you've ever done business with or used a service of. And more, those things actually require you to scroll down before it will let you say, I accept these terms and conditions. Now, you may be like many people who scroll as fast as possible and then click it because you know it doesn't matter what they are. I want to get to the next screen. But you may want to think about something like that in order to ensure that people have to go through the disclosure and then click, I affirm, I've read this, I have actual knowledge of its contents. And so that's an important thing to think of. If you do have a service provider, if they have not already generated a conversation with you on the impact of Sulyma, I'd bring it up with them and see if they have any plans for how to manage this. The difference between a 3-year statute of limitations and a 6-year statute of limitations is important. From a risk management perspective, the sooner you can reach the point at which you're no longer liable for prior decisions, it makes it easier to manage your overall risk related to your plans. And so to the extent you're able to work with your service providers or work internally to deliver these solutions in a cost-effective manner, because you do have to figure out what's the cost, not only the economic cost to you of creating the solution, but what's the employee relations cost that people are going to experience when they go in to get their plain documents or to receive certain communications, and they're now spending more time interacting with it. You may say that's a good thing. People should spend more time interacting with their benefit programs. Or you may say, gosh, that's just going to anger people as they try to access those documents. And so we don't want to manage that. We'll accept the 6-year statute of limitations. But I think it's a great question to have internally. So we're here at a little after 12:50, and we have an opportunity now for a few minutes to answer questions. And I don't know if we've got any pending questions that have come up. So if you've been sitting on a question, I encourage you to go ahead in that Q&A function and get that question submitted so that we can get it answered today. I saw something pop up. I wonder what it is. So we've had a question actually related to Bostock, and I appreciate this question coming in. There might be a pause because Stephanie reads them to me, and then I'm going to read them back to you. So we're trying to manage through this. But the question was related to access to multi-stall or multi-user restrooms for people whose gender identity does not match their biological sex. That is a challenge because well, it may be a challenge. Let me back up a bit. If you're offering both kind of the unisex single stall option as well as the multi-user option, you may feel, gosh, I should be allowed to tell people who happen to have a different gender identity than their biological sex, why don't you use the single stall? And I know we're going to have litigation about that in the coming years as to what the legally correct answer is. I would say that you're probably in a position, unless you want to be a test case, of while you can let the person who is experiencing a transition or has a different gender identity know that you do have the unisex option available, the single stall available, so that they can use that. I would not recommend requiring the person to use it, because you are making a decision based because of sex. From the Supreme Court's perspective, that choice you're making is because of sex. Now, whether that choice actually results in liability is a completely separate question. In order to have liability under the key employment discrimination laws, from a discrimination perspective, it has to be an adverse employment action. And I would I think just about any employment attorney on the defense side could make a very good argument that asking somebody to use one restroom over another restroom is not an adverse employment action. If it's a retaliation case, you have to show that it's a materially adverse action, which is a broader standard. Still, I think you could make a very good case that asking somebody to use one restroom versus another is not a materially adverse action. I say that with a big asterisk. It's still, the one you're asking to use needs to be at least as nice. You couldn't actually convert a dirty broom closet into a single-use restroom and say that, oh, you need to use that one. That I think you're going to have trouble getting over the hump there. But if you're providing equally as nice restrooms, then I think you might avoid liability. Your challenge is going to be, that feels very much like kind of a separate versus equal feel, that you're telling people that you've provided them separate facilities and they're just as good. And I don't know that I would want to be in a position of having to defend that decision, but that may be where you're at as an employer. And you may feel most comfortable doing that. So I can't tell you today that is that requirement would be illegal. Now, if all you have available is the multi-user, then the best advice is that you need to allow people to use the one that matches their gender identity. Now, we talk about this. I think the challenge is, let's say you have an individual who presents as male and has always presented as male, and let's just assume that this person, I'll call him Frank, is biologically male. Frank can't just come in one day, continue presenting as male and say, I feel my gender identity is female and I'm going to start using the women's restroom. I would have serious concerns about Frank's intentions and his purposes there. So you do have the opportunity in the midst of these conversations to really think through what's going on here. But if Frank comes in one day and says, I'm going to start presenting as female and I'm identifying as female, and I'd prefer that you address me as Frida, and, then starts coming to work, outwardly feminine, then Frank's going to be able to use the women's restroom. And then to the extent, and it's not Frank anymore, I apologize, it's Frida now, and Frida's going to be using the women's restroom. And then the only question becomes, is Frida behaving appropriately in the women's restroom? And that's a question for anybody using your restrooms. Is the person behaving appropriately with regard to their coworkers? And as long as Frida behaves appropriately, there's not an issue, even if other employees are uncomfortable. So I hope that answered the question that was out there. Do we have any more questions?
Gender identity. What if a biological male identifies as female but comes to work unshaven?
Okay, great question. So the question that came in was, what if someone who is biologically male states that she identifies as female and comes to work unshaven? This is a great question because it actually gets to some prior Supreme Court case law about gender stereotyping. And it also goes with the example I just gave a moment ago of Frank saying that he wants to identify as female and still presenting really as Frank, fully male, with no discernible difference in presentation. And then, I think legitimately be able to claim, is this a true change in gender identity? I would say that I'm going to give the answer today, but that kind of situation is one you really want to be in close contact with your employment lawyer about, because it's very nuanced here. But I would say somebody who is presenting as female day to day, even though their biological sex is male, if they happen to come to work unshaven at times, I probably am not going to question that as long as they have other indications of female presentation. Because you don't want to be in a situation, and once again, I think some of this is largely hypothetical. In all the advice I've ever given and all the cases I've read, I have yet to find a single one where you have somebody who in fact is biologically male, truly presents as male and wants to be male, but is pretending to present as female in order to have access to a women's restroom or locker room. So I think that kind of conversation really speaks to people's fears, but not actually is not about their realities. And so while we can play that out as a hypothetical, I don't think that that's probably something you're ever going to run into. However, if that question did come up and you found somebody who is biologically male, seems to present as male, but claims to have a female gender identity and wants to use the female facilities, that's a question you need to really be having a good conversation with that person, a polite, kind, pleasant conversation where you want to understand where they're coming from, and then turn right around and have that conversation with your employment attorney about how to approach that. Because those are going to be the situations, if they were to ever exist, where the issue with other employees is real, with them saying, why is somebody who fully presents as male in the women's restroom? So I think that's a legitimate question for people to ask. Any other questions? Okay, well, I've been told that we are out of time. So if you have a pending question, I will follow up with you. But before you get off, I want to make sure that we don't lose our winner. So I mentioned at the beginning that we're going to be awarding a Southwest Airlines gift card. And I am so sorry, I may butcher your name, but our lucky winner is Quinnen Burdine. So congratulations, Quinnen. We will contact you after the webinar to coordinate delivery of your Southwest Airlines gift card. So I want to thank everybody for being here today. I very much appreciate all of you for taking the time to log in. You can look forward to getting a copy of the corrected slides, as well as that HRCI and SHRM credit information. tomorrow, and we hope you'll tune in again next week when Mary Snyder will be presenting the firm virtual webinar for that week. Thank you very much. Have a great day. Bye-bye.